Hello, and welcome to another topic lecture on my channel. My name is Jet Smith, and I'm the head coach for speech and debate at Highland High School in Pocatello, Idaho. And the main goal of this video is to provide free and easy to access resources to help you learn how to succeed in speech and debate. Now, with the new year brings new topics, and this year is no different. The January-February 2025 resolution reads, "Resolved, the United States ought to become party to the United Nations Convention on Law of the Sea and/or the Rome Statute of the International Criminal Court." Now, many Lincoln Douglas debate topics have been controversial in the past. However, this one has sparked a lot of concern and outrage from both the progressive side of our community and the more traditional side of our debate community, who are worried about a topic like this in Lincoln Douglas debate, as it's kind of the first of its kind using the and or and including two seemingly different and opposite, or at least not relevant to one another halves. Although my goal of this video is to convince you that no matter what type of debater you are or what type of debate you do, that you can enjoy and succeed on this topic. So what are we going to talk about in this lecture? Well, first we're going to discuss the resolution itself, break down the wording, why we might be debating this, what type of topic it is, and we'll talk about how to approach this as a more traditional debater if you're worried about, does this topic mean that you have to read a plan or that you have to read multiple neg cases? And spoiler alert, the answer is no. Then we'll talk about framework arguments, how you can set up your value criterion and standard to ensure that you teach the judge how to make an ethical decision on the topic. Then we'll go over 10 arguments on the affirmative, a couple that could work as a more generic philosophical approaching both halves of the resolution side, as well as some arguments specific to the law of the sea and the Rome Statute. And then we'll do the same with 10 negative arguments. So next, let's break down the resolution into 5 different aspects: trichotomy, definitions, background, stakeholders, and core issues. First up, we have trichotomy, which is essentially asking, what type of topic is this? And trichotomy says that there are 3 main types of topics. There are policy topics, fact topics, and value topics. And this topic, again, the United States ought to become party to the United Nations Convention on Law of the Sea and/or the Rome Statute of the International Criminal Court, is a policy topic. In fact, it sounds like a policy debate topic because it says and or. It essentially says that the judge is going to choose to say that the policy is a good idea or a morally required idea. So it is a policy topic, but we're likely to talk about value judgments on the topic, as this is Lincoln Douglas debate. So next, let's get into what this topic actually is. So the United Nations Convention on the Law of the Sea is a treaty, just like the Rome Statute. So I think this topic will become known as the International Treaties topic, because that's faster and more simple than saying UNCLOS and ICC. So I paraphrased this from the United Nations itself, and essentially this treaty is a comprehensive framework that governs how we're allowed to use the oceans, and it sets up boundaries in those oceans as well. It says that states that are along the coast have sovereignty over the 12 nautical mile territorial sea, as well as sovereign rights within 200 miles of their country, which is the exclusive economic zone, or EEZ, which allows them access to resources and requires them to be stewards for environmental protection, while also making sure that other countries still have the right to navigate, fly over, and have underwater cables in their exclusive economic zones as well. Now, UNCLOS also defines rules for how you can pass through straits, archipelagic waters, and the high seas, and it focuses on cooperating to make sure that we conserve our marine environment, prevent pollution, and boost scientific research. Even states that are not touching the ocean, or landlocked states like Somaliland or Somalia, which is one of, sorry, not Somaliland or Somalia, Ethiopia is a landlocked state that actually has an interest in the law of the sea. Because of that, it also guarantees that states that are landlocked have access to the sea and can participate in resource sharing. And disputes over whose territory is what or what actions people take can also be solved through the International Tribunal for the Law of the Sea as part of the treaty. The convention also tells you what rights you have to the continental shelf and revenue sharing for resources that you might find beyond 200 nautical miles. So it is a large thing. If you read through the entire Law of the Sea, I believe it is hundreds of pages. Or a lot of pages, because there have been so many amendments and things added to it. It's definitely a lot longer than the Rome Statute is, so there's a lot of different room for debate there. But speaking of the Rome Statute, let's now talk about the Rome Statute of the International Criminal Court, and I got this from the International Criminal Court's website, paraphrased it from there. So the Rome Statute is also an international treaty, and it is the treaty that created the International Criminal Court, or the ICC, which focuses on prosecuting 4 different types of crimes when countries are unwilling to prosecute or unable to prosecute those crimes when committed by leaders and officials of their countries. These crimes include genocide, crimes against humanity, war crimes, and the crime of aggression, all of which are defined in this paraphrasing. Now, the ICC only steps in, as said before, when the governments of these criminals or suspected criminals are unable to, which makes it a backup option and not a replacement. The court requires that countries help investigate the crimes that it's looking into and provide funding, as it doesn't have its own police force. It's an international organization, not its own country. So cases can be brought to the ICC by countries that are part of the treaty. It can also be brought by the United Nations Security Council, which the United States is on. Or there are prosecutors of the ICC that can do investigations and then launch their own cases. Now, the legal process, just like anything else, includes getting evidence, pretrials, trials, and appeals, and every accused person is considered innocent until proven guilty. Now, the International Criminal Court is also made up of judges, prosecutors, and other staff who handle cases, investigate crimes, and support victims, and they are provided by countries that have joined the treaty, known as state parties, and they help it by funding it, by electing its judges, and cooperating with its investigations and other aspects of its work. So, and becoming party to it is exactly what this resolution is about. So now let's talk about what it means to become party to something, which is essentially a different way of saying accede or talking about accession. And accession is when a state accepts the offer or opportunity to become a party to a treaty already negotiated and signed by other states. It has the same legal effect as ratification. Accession usually occurs after the treaty has entered into force. So because these treaties already exist and the United States is not party to them and did not ratify them upon them being created, we now will just accede, which is like ratifying after everybody else already did all the work of negotiating these treaties. The United States was involved in the discussions that created these treaties, but because they weren't a huge fan of what the end result was, ended up deciding not to join. Now, if you want to understand how one accedes or becomes part of a treaty, you can look at the treaties themselves, and I've posted links to those and told you which articles you can check to see what countries have to do to become party to a treaty, but it's a pretty straightforward process, especially when we have the magic of fiat. In other words, we get to debate about what ought to happen, not necessarily what will or would happen. So now let's talk about why we're debating this topic in the first place. The reason why I think we're having a treaties topic is because there are tons of international agreements that most other nations similar to us have joined, or a majority of the world's countries have joined. And yet, 2 of these agreements that we have not joined are the Law of the Sea Treaty and the Rome Statute. Now, the main thing that I think is stopping us from joining these is the fact that in order to ratify a treaty, 2/3 of the Senate must vote to sign it, partially to overcome like the filibuster, and because we just have certain laws that set it up so that it's kind of hard for us to join treaties. And we're also afraid of losing our sovereignty or our ability to make our own decisions as a country. So the United Nations Law of the Sea Treaty is one that most countries have signed, and we, in fact, even though we haven't signed it, is so commonly agreed upon as the law of the sea that the United States basically follows most of its rules, because everybody that it wants to work with follows those rules and plays by those rules. Likewise, the United States has worked with the ICC under Article 12 as a non-party state with some cases, but it's not a part of the treaty, which means that it can't really shape or fund the court. Now, I especially think this topic is timely because with Donald Trump becoming the next president, his second term is not very likely to increase international cooperation on the front of treaties like these, which means that you have a pretty strong inherency, or the status quo will have problems that won't be solved unless we follow these treaties type of claim. So that's kind of what brought us to discussing this topic. Now, who is affected by this topic? Many different groups of stakeholders are affected, including US politicians and military officials who could potentially be prosecuted or be part of criminal cases in the International Criminal Court. There are also marine ecosystems at stake, and as well as the victims of abhorrent crimes in civilian and war-torn countries. Those are all more of the ICC side, but businesses would also be stakeholders for the UNCLOS side, and just U.S. citizens in general, based off of the importance of U.S. territorial military safety and resource access from the UNCLOS side of the topic. Now let's talk about what the main issues at stake on this topic are. What is the core clash between the affirmative and the negative? I think the two main things that you're going to be discussing are what is more important, accountability or sovereignty, and who are we accountable to? Or who should we be accountable to? And at what point does sovereignty matter, but not more than maybe our international obligations? And as well as speaking of obligations, what obligations should the United States care about most, or at a certain point, when are we allowed to have international obligations? The negative is going to say that we need to focus on national obligation more, and the AF is going to, of course, say that we need to focus on international obligations, that governments it exists in the modern world, not just in their own little tiny bubble, but the things that they do affect everyone else on the planet. So if you have been primarily worried about this topic, thinking, I don't even know if I want to do LD on this topic, or I don't know how to coach or how to debate or how to judge on this topic because it just seems so weird, this next part is where I'm hopefully going to be able to put you a at ease. If you buy the champion briefs, which I had already written out this whole lecture before those briefs came out, and then I read the topic analysis, the very first one, and it was phenomenal, and I was like glad to see that I'm kind of on the right track. But if you have the champion briefs, actually read that first topic analysis, and I think it will help you be less afraid as well. But sometimes when we get policy topics in LD, we don't really know how to react. And I think that this topic is actually less policy than both of the other options that were presented, although I didn't think that at first. The first thing that you need to keep in mind is and or just means either or both. It means that you essentially has three options as the affirmative. You can defend the entire topic, in general, and you instead pretend like the resolution was saying the United States ought to become party to more international treaties. And imagine that you wrote a case on that topic, and you base it on signing international treaties and becoming party to them and following their rules is a good thing. And that is the traditional philosophical, morality, ethics-based discussion that you want to have if you are not interested in the more progressive style of argumentation. However, you can also, still debating traditionally or progressively, also choose to make the topic smaller and maybe easier to defend by only defending one half of it, either affirming on the law of the sea side or affirming on the Rome Statute side. Both of those are options. So really the affirmative can choose to defend the entire topic in general, just pulling examples from these two treaties to prove the overall concept of signing international treaties is a good thing to do. Or you can choose to defend the merits of either specific treaty. And I think that if you want to discuss the merits of both specific treaties, then it's going to be a lot harder to do that as opposed to like the general philosophical principle, or just picking one and hammering out the details of that specific treaty being good. Now, the negative can write generic contentions that also apply to why signing international treaties like these is a bad idea, and then just maybe have a link to each half of the topic, and if they don't defend one side of the topic, just don't read that link. Or my recommendation would be write one or two contentions against each half of the topic, and if writing 4 contentions sounds like a lot, work with a teammate, and then each round react to what the affirmative does and just read the best ones. So for example, if your opponent reads their generic case that defends both halves of the topic, then read your best contention against law of the sea and your best contention against the Rome Statute. If they only defend law of the sea, read both of your law of the sea contentions. If they only defend Rome Statute, read both of your Rome Statute contentions. You really shouldn't need to write more than 4 contentions to be able to survive on this topic, and really and truthfully, you shouldn't need to write more than 2 if you write a really large contention for law of the sea and a really large contention for Rome Statute. So next thing to understand is that when you debate this topic, if you look at those core issues of accountability versus sovereignty, of national versus international obligations, and you treat the topic as international treaties, ought we sign more of them and become party to them or not, then that can give you the more traditional side. If you want the more progressive side, then you can read plans and counterplans that are specific to either of the two treaties themselves, and criticize those treaties or support those treaties, and you'll be able to have a lot of room for argumentation no matter what style of debate you do. Now let's talk about framework arguments. I think there's a lot of good framework options on this topic. And finally, we have a topic where justice makes sense at least a little bit as a value. Now, if you are defending the International Criminal Court side, I think justice makes a lot more sense as a value than if you were to just defend the Law of the Sea Treaty side, because the whole point of the International Criminal Court of Justice is to get justice. But you can also say that treaties are about international law, and law is inherently about justice. So you could affirm justice even if you were doing UNCLOS, if you're reading the generic philosophical treaties are good AF, or if you're reading an ICC Rome Statute AF. The other option, good old reliable morality, is about what the topic ought to be, or what ought to be done. And this is, I think, especially good for cases on humanitarian concerns. It's probably better for the affirmative than for the negative, and it's probably better on the International Criminal Court side than the Law of the Sea Treaty side. Now, real quick, I know that there is a lot of people watching who probably think that they don't understand why I even say you should read morality as a value in these topic lectures, because morality is not a value. That's like saying my value is value. It's too vague. It means nothing. And I used to feel the exact same way. I would highly recommend you take the National Speech and Debate Association's Intro to Framework course, their Intro to Philosophy course, and their Intro to Coaching Lincoln Douglas Debate course. All three of those free courses, as long as you have the resource package, will really help you understand framework on a more deeper level, and understand that while your value premise is the ultimate thing you're trying to achieve, most value premises collapse down into being just a theory of the good, something that we want, something that we want to achieve. And most of the time it collapses into goodism. So there's really not a huge difference between valuing justice, morality, or governmental legitimacy. The main concern in your framework debates should be about the criterion. But the reason why morality can work as a value is because it comes from that word ought, which is about moral obligations, which is in almost every single topic. And then your criterion very simply explains to the judge, your job in this debate is to do what is right. How do you know what is right? Use my criterion. Your job is to be more good than bad. Your job is to follow good moral standards and do what you ought to do, just like the topic. So governmental legitimacy is the third value that you can read, because it's a topic about what the US government ought to do. I think it's good for cases about nationalism, libertarianism, sovereignty. So I think this value probably works better for the neg than it does for the AF, although you certainly could read it on the AF. And it might work better, again, on the ICC side than it does on the UNCLOS side. So I think that overall framework will probably be easier for you to debate if you're on the criminal court side of the topic, if you want to have like specific philosophies, whereas like the straight up utilitarianism, consequentialism type of big shtick impacts, frameworks and standards will work better on the ICC, or will work better on the Law of the Sea Treaty side. I have a bunch of different criterions that you can use. Again, please take those courses that I mentioned earlier, and it will really help you be better at framework debate. Just remember the criterion should be an actionable thing that the judge can do with their decision. So they should make this a decision that does blank. So please don't say my criterion is, Hobbes contractarianism. My criterion is Kant. My criterion is utilitarianism. My criterion is human rights. Give them a phrase, something like respecting human rights, something like ensuring consistency with Kant's philosophy, or fulfilling one's duty to avoid harm. Use a phrase that makes your criterion easy to understand, then use a philosophy to explain where you got your criterion from and warrant why that criterion is the best way to make good decisions. So now that you can kind of see how you might tell the judge to approach making a decision on the topic through your framework, let's talk about the affirmative arguments about why we ought to become party to either the Law of the Sea and or the Rome Statute of the International Criminal Court. Let's start with some of those generic or general philosophical principled arguments that would apply more traditionally and to both halves of the topic. The first one that comes to mind is the concept of accountability, or taking responsibility for your mistakes, and responsibility both in blame and in what to do after. So this argument would say that right now we don't really think we need to take accountability for the mistakes and injustices that we cause on a global scale, even though we have many failures as a nation, just like all nations do. And when we sign international treaties and agree to be bound by their rules, we are going to take accountability for our future mistakes and agree to take accountability for them, commit to doing what is right to right our wrongs, and we're also less likely to make those types of mistakes in the future. And you can talk about how accountability as an impact is essential to justice because it helps us mitigate the harm that is done to victims. It helps us restore people's rights when they've been taken away and make sure that we have fairness, which is a core tenet of justice. The second general philosophical principled argument that you can make is the affirmative, is about international law legitimacy. This says that international law is really important, but the United States undermines its importance by failing to uphold it and follow it now. And when we become party to these international treaties, we give legitimacy and credibility to these international laws, makes it more likely that people accept these as the real deal, as important. They're kind of only as important as we believe they are, just like how court rulings only work because people agree to follow them. International law is only international law when it's followed internationally. And so when we follow it, it will make it stronger, which means that there's less likely to be conflict, we'll have better alliances, and our nation and globe will be more unified. Next, we'll talk about a couple of arguments on the law of the sea side. The first of which I think is environmental protection. So currently, we allow companies and our military to do a lot of things in our oceans that are bad for our marine environment. But if we become party to UNCLOS, then we could put an end to those actions, and we would also create obligations as part of being in the treaty to protect our environment, our marine oceanic environment that is part of our territory, as well as just globally, anywhere that we want to extract resources. And this is good because it could help us save certain species from extinction. It could help us slow or reverse ocean acidification. We could mitigate climate change, any sort of environmental impact that you can think of that UNCLOS deals with, and there are a lot of them. Next up is dispute resolution. Currently, because the United States is one of the only countries that isn't part of the treaty, we don't really have the same systems in place for when people disagree with us about what we do in the ocean, or when we disagree with others about what they do in the ocean. But the United Nations has certain processes and a whole tribunal that is specifically dedicated to helping countries, companies, and private individuals figure out who has the right territory, who has the right claims, what is the proper course of action when disputes happen, which means that we can have better outcomes when those problems do come up. It will help us avoid economic issues as well as potential military conflict and escalation as a result of unresolved issues in our oceans. Next up, we have international law, influence, and leadership. We want to be the hegemon or the most influential, powerful country in the world, and yet because we refuse to be part of these treaties, like UNCLOS, we can't really shape the law of the sea if we're not part of the law of the sea. So we complain about the different parts of it that we don't like, but we don't really have a voice to improve those laws because we're not part of the largest forum on earth where oceanic laws are discussed. And if we become party to this treaty, then we can help shape the amendments, the decisions, and the priorities for the treaty and all of the organizations that function underneath it. And if we lead UNCLOS, that is essential because the world continues to change with artificial intelligence, with new diseases, with climate change, and we need to be able to respond to those things, as well as respond to the influence of Russia and China in our oceans and across the world. And the United States' presence in the organization of UNCLOS, the treaty, would probably help with that. Argument number 6 is another one for UNCLOS, and that is about resource access or protecting our access to resources in the ocean. This argument says that fishing populations, oil and natural gas deposits, rare earth minerals, all sorts of resources that we really want are in the oceans. And while we technically use them now, our access to them is not legally protected or guaranteed, particularly in the event of a dispute. And If we join UNCLOS, then we have legal and protected access to these resources, which means that we will ensure that they continue to benefit our economy and our country. And it will also help us make sure that we can distribute some of those resources to developing countries, to landlocked states that need them to improve the global economy. And if we have this resource access, we'll have be able to stop things like food scarcity, we'll have better energy independence from oil and gas, and we'll have the ability to build green technology that depends on rare earth minerals that we can a lot of the times only mine in the sea. Next up is an argument for the Rome Statute, or the International Criminal Court side of the topic, and that is alliance building. Now, we want to have strong alliances, but it's difficult to do so in the area of international justice because we're not part of the biggest international justice movement on the planet with the International Criminal Court. So our allies that are part of the court can't count on us and depend on us and share resources and count on us to provide funding, count on us to provide intelligence, and do what is right in the court because we're not part of it. So if we become party to the statute, then we'll be able to cooperate with our allies and stand with them on international justice. And this just basically says any way that we can improve our alliances is good because improving alliances deters conflicts and improves trade with those countries. Next is deterrence of atrocities, again on the International Criminal Court side of the topic. This argument says that there are a lot of bad people in the world who are not really afraid of the consequences of what will happen if they engage in horrible human right violations and all sorts of things that the International Criminal Court deals with. But those people are frequently afraid of the United States. And when we join the International Criminal Court and our intelligence, our resources, our support of the court is now recognized, then our allies and non-allies, but those that are afraid of what the United States reaches, will be less likely to engage in these horrible acts upon us becoming party to the Rome Statute as a deterrence factor. This means that we can help prevent genocide, war crimes, crimes of aggression, and human rights violations. The ninth argument is about protecting human rights. Speaking of which, there's a lot of similarities on this topic, but this would be a more human rights focused argument that basically says that we care about human rights a lot, but there are many countries across the world and even in the United States that we violate human rights through our military and political decisions. And if we become party to the Rome Statute, then we will be more likely to ensure the protection of our own human rights of American citizens and the protection of human rights of citizens in other countries that we do business in and that we take military action in. This means that we will protect human rights from being violated, we will reinforce standards of what human rights even mean, and we're more likely to get justice for victims that when their rights are potentially violated by United States action. The 10th argument could be a link to other arguments as well as an argument of its own, and that is funding the court, where the biggest problem with the ICC right now, according to many, is that it is lacking in personnel and funding, which means even if its intent and what it wants to be is really noble and awesome, the court can't really do its job. And becoming party to the Rome Statute would obligate the United States to contribute funding to the ICC, which would help it do its job. So any argument that you can find about why the ICC is good, any argument about what it does, what it's trying to do, what it wants to do, about how many cases it can get, about wait times, about investigation tactics, anything like that, you can make an argument that America joining the court will improve that thing and make it better simply because by joining it, we become obligated to fund it as per one of the amendments that's in the agreement. So now that we have 10 arguments as to why we should join these treaties, one or both, now what are some reasons why maybe we would not want to become party to either of these treaties? So I have 4 more generic arguments because I think it's important for the negative to have arguments that you can read no matter which half of the topic that the affirmative chooses. But with each of these generic arguments, my recommendation is have 2 link arguments, one to the law of the sea and one to the International Criminal Court, and then just skip one if they don't read that part of the topic. That way you can read these contentions no matter what they read if you go for one of these both arguments. The first of which is a military flexibility argument. And this argument says that the military is very powerful in the United States, and we have a lot of tools at our disposal and flexibility and options to help defend our citizens and the rest of the world. But by becoming party to either or both of these treaties, there will be restrictions, doubts, reservations on what our military can and can't do, which means that there will be increased hesitation, slower decision making, and we'll just have less offensive and defensive flexibility, and our enemies will know that. That means that we are less able to project power and deter aggressive acts from our adversaries, and leaves us more vulnerable to what people will do against the United States if we are in a conflict. So the second generic argument that you could read as the negative, no matter what the AF is kind of about, is nationalism or something rooted in nationalist philosophy. Nationalism is the concept that we should be focused on protecting our own nation and our own citizens. If you've heard stuff about America first, that's an example of nationalism. And we're trying to be more focused on that in the status quo. Trump becoming president is an example of that. And when we become parties to these treaties, we are putting obligations and responsibilities on the United States that can conflict with our domestic responsibilities to our own citizens, and we won't be able to put America first when we continuously agree to follow these treaties that restrict our rights and access. And nationalism, you will argue, is good because it protects American hegemony or the ability to be the strongest in the world. It helps us fulfill our domestic priorities, and it helps keep our country unified and on the same page when we are deeply divided. Another argument you can make is sovereignty. I think this is kind of the core neg argument of the topic, whereas the affirmatives is probably just accountability or international law being good. Ours is that sovereignty is good, or the ability to and right to govern your own country and have the ultimate authority to make decisions for your citizens as a federal government of your country is sovereignty is pretty important to the United States. It's the number one argument given by both Democrats and Republicans for why we don't join these treaties. And when we become party to these treaties, we violate our own sovereignty by giving power to people outside of the United States to restrict the decisions and the rights of our citizens. And that is bad because it diminishes our democratic values, the idea that your government should be by and for your people, and it makes it harder to ensure American interests get fulfilled and serve our own citizens in favor of citizens from other countries, which is not the primary focus of the United States, or at least it shouldn't be according to this argument. The final generic argument that I'll give you is an interesting one, and I think that writing it well will be difficult but rewarding. And this is basically saying that rather than focusing on the letter of the law and becoming party to these treaties, the United States should, rather than respecting laws that we sign, respect customary law, or the idea that agreements that are like gentlemen's agreements, things that so many people do that we just think that it's the right thing to do. Like, there's no law that says you have to open the door for somebody who's carrying a bunch of groceries and walking in at the same time as you. And yet we follow that because it's just a well-known principle. Or that you put your phone away when you're talking to people. These things say that we should do the right thing simply because it's the right thing, and not because we signed some sort of agreement or there is an enforcement mechanism that requires us to. So this would basically say that rather than becoming party to these treaties and following them because we have to now, that we should follow the tenets or the goals or the central ideas of these treaties because we choose to, because we want to, rather than because we're legally obligated or required to. And the argument here, it's kind of like a counterplan, but it's also what we're mostly doing in the status quo, so you don't have to read it as a counterplan, is that we follow the tenets and the philosophies and the major ideas of these treaties, even if we're not part of them, so that we can maintain our flexibility or maintain our sovereignty, but still uphold good ideas. And there's lots of evidence out there about how customary international law, or countries basically having gentlemen's agreements or agreements to do the right thing without necessarily putting it on paper, ends up producing better results in the long run than these imperfect and flawed treaties. And it's better than signing the treaties because it avoids any of the previous arguments that we've given before this one. So this is a sort of counterplan, and honestly, this is the only counterplan that I have. This is not going to be a very counterplan heavy topic, especially for like traditional or like medium traditional debate. I think that really the only viable counterplans are going to be plan inclusive counterplans, or PICs, where you basically say, I agree we should join these treaties, but only these parts of the treaty, or we should pass the treaties as United States laws, except for this one bad amendment or this one bad part. And the negatives will basically try to say most of the treaty is good, but because this one part of the treaty is bad, affirmative should lose and you should vote for me to get most of the treaty, but not the whole thing. So I think those don't appeal as much in traditional debates or to lay judges. So I really don't think this will be a very counterplan heavy topic. The fifth negative argument area is specific to the Law of the Sea Treaty, and that is about economic burdening. This disadvantage or contention says that we benefit a lot from the resources we get in our territory in the ocean, but signing UNCLOS means that we have to pay royalties now on what we collect in our resources to the International Seabed Authority. We'll also probably lose a ton of money from our companies and in taxes on trying to comply with all of these new laws and standards that we just obligated ourselves to follow on the environment and on maritime safety protocols, which is bad because it means that it will be more expensive to do business in the United States, with oceanic resources becoming more expensive and riskier, which means we'll have more inflation and lower economic growth. Next argument is about energy prices or energy independence, which says that we need the oil and gas reserves that are in our oceans, and we need to be able to drill them pretty much freely without restriction to make sure that we can keep prices for fuel low or lower than they would be. But by becoming party to the treaty, we're once again required to follow environmental regulations that could make it so we can't access those resources anymore, and we might even have to share those resources or lose territory of those resources that we currently drill from if we agree to follow all of the territorial requirements of UNCLOS. And energy independence and having energy prices low is essential to United States security. It's important for our economy and to making our constituents happy. The seventh negative argument area for this part of the topic is the exposure to lawsuits that would likely occur if we joined UNCLOS. Right now, we do what we do in the ocean based off of bilateral or our country to one other country agreements with our allies, and we mostly follow a lot of what UNCLOS says. We follow customary international law, but we're not bound by it, which means that if other people are upset about what we do, there's not much that they can currently do about it. But when we become party to UNCLOS, we're required to follow their mechanisms for how to get over disagreements, which means that we would become eligible to be sued for what our companies and our government actions do in the ocean by other countries, by non-governmental organizations, or even private citizens of other countries could sue over environmental, economic, and military activities that take place in the ocean once we sign this treaty. And lawsuits would be bad because the United States government and its companies could pay tons of financial penalties. We'll have legal uncertainty, which makes people less likely to invest in our projects, all of which will probably hurt the economy and financial status of the US government. Next, let's talk about a negative argument on the International Criminal Court side of the topic. This is increased spending, where we say that the United States is trying to rein in government spending, or at least is trying to rein in government spending on stuff that doesn't return on investment for the American people, right? So if you spend on a program that's meant to help your citizens then grow the economy themselves, then that type of spending we're more okay with than stuff that we're never going to get back. And when we become party to the Rome Statute, we are just dumping money into a program that we know we will never get money back on. It's going to take a ton of money from the United States to make the court really able to do anything all that much. And because of how big the US economy is, our obligation would be bigger to help them. And that's bad because spending a bunch of money on the court is not going to grow our economy. It's not going to benefit American citizens, but it could increase our national debt, or we may have to increase taxes to be able to pay for this, or we might have to cut spending on other international programs, all of which you could argue is a bad idea. Ninth argument for the International Criminal Court side is unfair prosecution. This is a very common argument in the literature that says that the International Criminal Court is bad because it has a lot of political controversy and intense bias. It's not a very objective, depoliticized court, which is what we really want. They're biased against certain countries, ideologies, and people. And if we're party to the Rome Statute, then that means that that bias and political controversy could be used to unfairly target Americans, the United States, for politically motivated reasons based on anti-American bias. And that is bad because justice requires fairness, and there would be unfair prosecution and targeting and violation of American rights if we join the International Criminal Court. Finally, we have the rights of the accused, which I think will be a big negative argument for this side of the topic. And this basically says that the US Constitution and legal system in our country says that when you are accused of a crime, you have a lot of rights to make sure that even if you are seen as guilty, you are innocent until proven guilty. And we give you the tools to maintain your innocence and be treated decently well before you can prove it. And if we're party to the Rome Statute, that means that our American citizens and officials can be accused of a crime and not granted all of the rights that our Constitution says they should have, like a speedy trial, adequate representation, and a trial by their peers, because those are rights that are not necessarily guaranteed by the International Criminal Court. Even if they attempt to, they don't often in practice. And that is bad because if we don't ensure the rights of the accused, there could be wrongful convictions and violation of due process, both of which contradict with justice. So now let's get into the final thoughts on this topic. First things first, don't freak out. The topic isn't actually that big and it's not that crazy. Honestly, there isn't that much argument variety compared to many topics. So I think the reason they put Rome Statute and Law of the Sea is because neither was big enough to do 4 months of debate by itself. Affirmatives, you need to choose your strategy to make sure the negative doesn't choose for you. And whether it's defend the whole topic generally, defend just the law of the sea, or just the criminal court. And negatives, you need to be ready to adapt with a flex case, multiple contentions that you can choose to read when and if it serves you. And make sure that you work with your teammates, your friends, and your coaches so that you're ready for anything and nothing catches you off guard. Thank you so much for watching, and I will see you in the next video.